So again, Chuck, thank you for being with us today. I really appreciate you coming on.
Always a pleasure.
I want to start with Senate Bill 1327. This was the one that was modeled after the abortion law in Texas, but there was that one thing that they tacked on at the end of it, having to do with paying attorney's fees. Basically, it makes it impossible for us as a plaintiff or anybody else who's suing the state government to become a prevailing party, which would then force us to have to pay for the state's attorney's fees. I mean, for the second time, if you really think about it, because the taxes are going there anyways. So, what is the update that we have on SB 1327?
Okay, so that bill had two components. One created a private right of action for individuals to sue gun retailers, manufacturers for breaking the law, and so it wouldn't just be the state that would prosecute somebody; anybody could. And the other changed the definition of prevailing party in the law so that a lawyer suing to declare a gun law unconstitutional could never be the prevailing party. And since the law firm wasn't the prevailing party, or the CRPA wasn't the prevailing party by definition, couldn't recover the attorney's fees, which we've always been able to recover in the past when we win. And not only that, it made it worse because it shifted the prevailing party definition and said that unless CRPA wins on every single lawsuit, every single cause of action in a lawsuit, and typically you'll have four or five. Second Amendment being one, maybe equal protection, maybe due process. You have all these different causes of action, and unless you win on all of them, then the state can recover its attorney's fees from you. This is a way to bankrupt any plaintiff association or lawyer, for that matter, that wants to challenge a gun control law. Now, this was modeled after the Texas law, and I love Texas, but I don't like what they did with these laws. They passed laws to try and make it impossible for abortion proponents who want to advance a right to an abortion to sue the state over any abortion law that they pass, which would basically be something that would outlaw abortion in Texas. And so it's basically a way to chill participation in the legal process. Texas did it to keep those in support of the right to choose out of the ballgame. Newsom then modeled it after Texas and did it to keep firearms law firms and associations like the CRPA out of the ballgame. He mischaracterized things. Though I got to say, there was an amicus brief submitted by the California Attorney General in the Texas case saying that this shift of the prevailing party and attorney's fees was unconstitutional. So Bonta doesn't believe in this. He thinks this is unconstitutional, and so does Newsom. But they passed it anyway and claimed that the reason they passed it was because the Supreme Court had said it was constitutional. Well, no, the Supreme Court said no such thing. The Supreme Court just refused to grant a temporary permanent or a temporary emergency injunction against the abortion laws or those Texas laws, and then sent it back to finish litigating. So the Supreme Court never ruled on the merits. It just said, we're not going to rule on this at all right now, and sent it back down. So we're really calling the DOJ to task, because here they are saying that this kind of law is unconstitutional when they're arguing against the Texas abortion statutes, but they're now trying to claim that it is constitutional to do it in California. Anyway, we can't put up with this. It would make it impossible for us to litigate our civil rights. So we challenged that in court today, in fact, in San Diego. And we filed a notice of related case. We're hoping that it gets put in front of Judge Benitez, because the plaintiffs in our case are all the plaintiffs that are in the Duncan case and the Rhodey case and some of CRPA's other cases, because all those cases, we need to get this fee shifting provision out of the way before we can really move forward on litigating those underlying civil rights actions.
Well, I guess you heard it here first. So CRPA has dropped a lawsuit on Senate Bill 1327s. It's specifically on the prevailing parties. What is that? That's an amendment to the penal code, correct?
It's an amendment to the Code of Civil Procedure 12021.11. There's two different statutes, even though it's one bill, there's two different statutes being modified. So we're only challenging the modification to one statute. The private right of action, we don't believe that's ripe yet. In other words, it doesn't take effect till January 1st and no one has sued under it yet. That's basically what the Supreme Court said in the Texas abortion case. So I believe that the National Shooting Sports Foundation is going to challenge that private right of action portion as soon as they're legally able to do that.
Yeah, so I mean, just for ultimate clarity, what you're saying this amendment does is creates a situation where anybody who's bringing forth a lawsuit can win on 4 of the 5 things that they bring to the table. If one of them is thrown out, they are declared not the prevailing party, which can then lead to having to pay for the state's attorney's fees.
The state is declared a prevailing party, even though it only succeeded in getting one cause of action knocked out. And then you could be on the hook for the state's fees. It's completely unconstitutional. And we have no doubt it'll be struck down. It's just that it's in the way. We have to get this only gets us back onto the playing field to litigate the civil rights cases. It doesn't really advance your Second Amendment rights. It just gets this obstacle out of the way, which is stopping us from being able to move forward on some of our other cases.